हेलो एवरीवन, मैं सागर बम्बोली आप सभी का फिर से एक बार स्वागत करता हूँ कॉमर्स ट्रेजर पर। सो टुडे वी आर गोइंग टू डिस्कस फ्यू मोर MCQs ऑन इंडियन कॉन्ट्रैक्ट एक्ट 1872. Basically we are going to discuss today about the special contracts which are given as per the Indian Contract Act 1872. I have made two more videos on this. If you haven't seen that videos, you can just watch the video. Link is given in the description and in the I button. So without wasting much time, let's start the today's discussion. So the first question is, which of the following is not a special kind of contract as per Indian Contract Act 1872? So Indian Contract Act 1872 has given basically three types of special contracts, which are contract of agency, definitely it is; contract of bailment and pledge, definitely it is a special kind of contract; and contract of indemnity and guarantee is also a special kind of contract. Contract of sale of good, this is not a special kind of contract which is given as per the 1872 Act. The next question is, indemnity refers to. Now, as per Indian Contract Act, contract of indemnity is a contract which is usually done in order to safeguard against any losses. So in simple, indemnity is nothing but it is giving security against loss or making good for losses or providing a security against loss. This is what we can remember about indemnity. And whenever you make a contract to save yourself from any loss, then it is called as contract of indemnity. General insurance is the best example for contract of indemnity. The next question is, which of the following is not a right given to the indemnity holder under section 125 of Indian Contract Act 1872? Now first you have to understand who is an indemnity holder. Basically there are two parties in contract of indemnity. One is called as indemnity holder and another is called as indemnifier. Indemnifier is one who gives you security against your loss. Indemnity holder is one to whom the security or compensation for loss will be given. So which of the following is not a right given to indemnity holder is what they are asking. Right to recover damages, definitely it is an right. Whenever you are having a contract of indemnity, and in that case if the court orders you to pay any damages to the third party, you can claim it from your indemnifier. Right to recover cost, definitely it is also a right which is given as per indemnity contract. That is, you can recover all the costs which you have undergone for filing the case or for fighting the case in court for indemnity claim. Right to recover the sum paid under compromise also is an right which is given to the indemnity holder. This is done usually in the case when you are settling the case outside the court premises, then you can reclaim the amount from your indemnifier. Right to recover property ownership, there is no such right in case of Indian Contract Act to the indemnity holder. A contract to perform the promise or discharge the liability of a third person in case of default is called as. So in this case they are saying that if you are paying on behalf of another person in case of their default, then it is called as contract of guarantee. You are doing nothing but you are providing a guarantee to the third person that in case the person does not pay, I am going to pay on his behalf. When two or more persons give surety for the same debt, they are called as. So very simple, if there are two or more persons who are giving surety for the same debt or for the same amount or for the same purpose, then they are called as co-sureties, right? Remember this friends, those are called as co-sureties. The next question is, which of the following are types of guarantee? So basically guarantee are of two types. One is called as specific guarantee. Specific guarantee is nothing but if you are giving guarantee only for one specific transaction, then it is called as specific guarantee. If you are giving guarantee for multiple transactions or series of transactions, then it is called as continuing guarantee. So the right answer is going to be both A and B are the types of guarantee as per the Indian Contract Act. The next question is, transferring of possession of movable property for a particular purpose is called as. So very simple, this is called as bailment. Now what is an bailment? Bailment refers to nothing but whenever you are transferring your property or giving your property to another person, that is an movable property. Specifically it refers to movable property for a specific purpose, then it is called as bailment. What is pledge? Pledge is also a subtype of bailment wherein you are giving your movable property but as a security against a debt, then it is called as an pledge. Mortgage is nothing but whenever you are transferring the possession of an immovable property, then it is called as mortgage. Lien is nothing but if you are retaining a property, then it is called as an lien. In all the cases, ownership remains with the owner itself, only the possession of the goods are going to be transferred. A simple example of bailment is in case of an repair shop. Whenever you give your mobile phone to the repair shop, then it is a case of an bailment. Pledge is nothing but, for example, if you are taking a loan from a bank and you are giving gold against that loan as a security, then it is called as an pledge. Mortgage is nothing but if you are giving your land or property for taking off a loan, then it is called as an mortgage. And lien is nothing but if a person retains your property till you pay him the amount, then it is called as an lien. The next question is, which of the following is not an essential element of bailment? In case of bailment, transfer of possession, definitely there is done from one person to another person, that is from bailor to the bailee. No transfer of ownership, definitely it is also an essential element of bailment, that is you do not transfer the ownership. Only used for movable property, definitely it is true. Used for immovable property, no, this is not correct. So the right answer is going to be option number D. Which one of the following right is not given to bailor? Bailor is one who owns the property in case of an bailment and to whom he transfer the possession, he is called as an bailee. They are asking you about right of an bailor. So a bailor has been given many rights in case of Indian Contract Act. Right to the termination of contract, definitely it is a right which is given to the bailor. He can terminate the contract if he sees that his property is not being used correctly. Right to claim compensation, definitely it is also a right which is given to bailor in case if the bailee is not using his property correctly, then he can claim compensation for any loss which has been done. Right to lien, no, this is not a right of an bailor. Actually it is a right of an bailee, that bailee can retain the property until bailor gives him the payment which he has promised him to pay. Right to receive accretions, definitely it is also a right of an bailor. Simple example is if you give a cow to your friend for few days and in the meantime you claim it back, the cow gives birth to a calf, then you can claim both cow as well as calf in that particular case. So this is what is called as right to receive accretions or addition made on that property. The next question is, which of the following points is or are correct? So pledgee has a right to sell the goods, definitely it is correct. In case if you do not make repayments of loan, pledgee has a right to sell the property in order to get back the amount which he has given as a loan. Pledgee cannot use the goods which are being pledged, so definitely it is also correct. In case of bailment, you can use the goods, but in case of pledge, you cannot use the good. Those are only being retained as a security for the loan. Consideration is must for contract of pledge, definitely it is also correct, because without consideration or without getting something back in return, you cannot go for pledge. But in case of bailment, there may be or may not be an consideration. So the right answer is going to be all of the above points. The next question is, one who works or acts on behalf of the principal is called as. So he is called as an agent. So this is a very simple question. Principal is one who gives the instruction or on whose behalf agent works, and agent is one who works on the behalf of the principal or does what a principal says. The next question is, which one of the following is minor can both be principal and agent? No, this is not correct. Minor can be an agent. Yes, this is correct, because an agent does not have any liability. Minor can be an agent. Minor can be a principal. No, he cannot be an principal, because in case of agency contract, principal is one who is going to bear all the liability. Minor cannot be principal or agent. This is also not correct. So The answer is minor or an unsound person can become an agent, but they cannot become the principal. Which one of the following is not a way of creating agency contract? So agency contract can be created in many ways. Basically, we divide it into two categories. One is called as expressed contract, that is by oral or written, and second one is called as implied contract, which happens because of some circumstances. So let's see among these given options which is not a way of creating agency contracts. Agency by necessity, definitely it is a way of entering into agency contract. This is nothing but in order to save the principal from loss, you act on his behalf, and this is called as agency by necessity. Basically it is nothing but you help him in case of an urgent situation. Agency by estoppel, definitely it is also and way of creating agency contract wherein a person acts on behalf of his principal. Agency by rectification, this is also a type of creating agency contract wherein without the permission or without the authorization of your principal, you do a particular activity and later the principal rectifies or approves that transaction if he finds that it was done in his benefit or for his benefit. So agency by contingency, there is no such type of agency contract. So hope you are understanding these three types of agency contracts. Which of the following is not a way in which contract can be discharged? So contract can be discharged or terminated in many different ways. By performance, definitely, and contract can be discharged once both the parties fulfill their obligations or discharges their obligations, then the contract is going to be discharged. By mutual consent, this is also a way in which contract can be discharged. Mutual consent is nothing but when both the parties mutually agrees to terminate or discharge the contract. By impossibility of performance, in this case also a contract can be discharged wherein there is no possibility of performance of the contract. It may be because of some adverse conditions or adverse situation. By judgment of one party, no, there is no such way to discharge a contract. So the right answer is going to be option number D. So the last question for the video is, when a party to a contract fails to perform the contract, it is called as. The answer is breach of contract. So breach of contract is nothing but whenever either party cannot perform or fails to perform the promise which they have done while entering into the contract, then it is called as breach of contract. Hope you are getting all these points. If you have any doubts regarding to these MCQs, do comment me in the comment box. I'll try to solve those confusions for you. And if you like the video, please hit the like button, and if you haven't subscribed my channel yet, please subscribe my channel and do press the bell icon so that you can get a notification as soon as I come up with a new video. Thank you guys for watching the video. Meet you again with another video.